Hello, everyone. Good afternoon. My name's Alex Mills, and I'm General Editor of the ICLQ alongside the Director of BICL, Professor Spiros Maniatis, and we're delighted to welcome you all to this event. This event is one of the highlights of the ICLQ and BICL calendars. It's an opportunity for us to showcase some of the outstanding research which we are proud and delighted to publish across the fields of public international law, private international law, EU law, human rights law, and comparative law. Now, this event has three parts. First, the award of the Early Career Prize and a conversation with the prize winner for about 10 minutes or so. Second, the annual lecture, which will take about 40 minutes or so with the opportunity for some questions and discussion afterwards. And then third, this discussion will flow seamlessly into the final part of the event, the drinks reception, which will follow. And sincere thanks as always to our fantastic publishers, Cambridge University Press, for their sponsorship of the reception and indeed all their terrific work supporting the journal. And thank you, Rebecca. So let's begin with the ICLQ Early Career Prize. The Early Career Prize is awarded each year to the best article published in the previous year's volume of the ICLQ by an early career scholar. It's decided by the Editorial Board of the journal. And with thanks to the generosity of Cambridge University Press, it comes with the award of £250 worth of Cambridge University Press books. This year, I'm delighted to announce the award of the prize to Dr. Alexander Wentka for his article published in volume 73, issue 4 of the journal, The Armed Attack Exception to Neutrality in International Peace and Security Law. Dr. Wentka is a postdoctoral researcher at the University of Potsdam and Humboldt University Berlin, and a senior research fellow at the Max Planck Institute for Comparative Public Law and International Law. He completed his DPhil in 2022 at the University of Oxford, and just a few weeks ago, I think, was awarded the Francis Lieber Prize by the American Society of International Law for his book on party status to armed conflict in international law, published with Oxford University Press last year. Which was based on his doctoral thesis. So congratulations, Alexander. It's quite a year you're having. So I might sit down for the Q&A. And if I could just kick things off by asking, ask some questions about your article that you published. And I guess if you could start off by saying something about your inspiration for writing this article. So attentive readers of the ICLQ will have noticed that in the last couple of years, there have been quite a few articles that are in some way or other a reaction to Russia's invasion of Ukraine. A sense maybe in which this article could be viewed in that light, but it's also a kind of deeper issue in modern international law, isn't it?
Yeah, no, absolutely. First of all, I'm extremely grateful and humbled by this prize. As you rightly observed, of course, it is an issue, the issue of neutrality and how it applies to assistance given to the victim state of an armed attack. It is obviously something that has been relevant to Russia's war against Ukraine. But I actually came across it earlier while researching for my PhD, the DPhil on party status. And I realized at that point that I wouldn't be able to fit it into the 100,000 words that I had, at least not in a way that would do it justice. But this, in a sense, this wider issue of how this old body of law that is very representative, the law of neutrality, of how we thought of war conceptually in previous times, how that fits with how international law regulates war today, right? A sort of a regime of international law that was designed at a time when war was a way to settle disputes.
which clearly now it is no longer.
So, can you just introduce what is the law of neutrality, just in case people aren't familiar with it, to understand what this is that you're talking about?
Yeah, obviously. So the law of neutrality is a body of law that regulates the relationship between the parties to an armed conflict and third states, that is neutrals, and it imposes obligations on neutral states. To summarize in a nutshell, obligations that aim at keeping third states detached from the conflict. And also that means imposing restrictions on the parties, sort of not to unduly affect third states. So in a sense, as I said, it was, if we imagine war as a duel, a way of dispute settlement between duelists, then you want others to stay out of the circle of the duel, in a sense. So that was the main idea.
And could you say a little bit about what your argument is in the article? What's the sort of key points that you make?
Yeah. So as I hinted at the conceptual struggle that arises with sort of between neutrality as a body of law that has this old conception of war as a background and sort of the prohibition of the use of force that is so central to how we think about war today, and at many sort of different aspects of the law of neutrality don't really seem to fit with that change of paradigm. And I focused on the obligations of neutral states and how they sort of the obligations of neutral states can or not apply to assistance to the victim state of an armed attack. Specifically, can they hinder? And that was the question. Can neutrality obligations hinder states, say Western states, to assist Ukraine, for example? And I realized, and many people have made the argument beforehand, that no, it can no longer do so. But the way of getting to that result wasn't, I think, solved in a conceptually satisfying way. And I'm not saying that I have done so, but I've tried to put my sort of trying to suggest something that resolves the issue at the level of the law of neutrality, while many other approaches have been based on general international law, sort of arguing that self-defense could be useful here, sort of a fortiori, if you will, if self-defense permits you even to use force at the request of the victim state of an armed attack, collective self-defense, then you may also assist a state at sort of a lower level of military assistance, or collective countermeasures could be a way of getting to that result. But all these are disputed at the level of general international law. And I thought, well, maybe we don't have to resolve these questions for this specific question of the law of neutrality if we interpret the law of neutrality systematically in light of the prohibition of the use of armed force, of the use of force. So my contribution was meant to be methodological in that I made the argument that actually we can get to that result by way of systemic interpretation.
That's we'll come back to this, the question of methodology. It's a very important one in the article, but just on the sort of continued relevance of neutrality. I mean, there's a sense in which it seems quite archaic because we live in a world in which international law itself takes side, right? International law doesn't view conflict as a duel. It views it as someone is in violation of the prohibition on the use of force. Yeah. But on the other hand, there's also a sense, and maybe this is sort of very present with us in the modern world as well, that a lot of the concerns around the law of neutrality, preventing conflicts from escalating, from involving more states, from kind of spreading, that those remain very present for us as well. I mean, if we sort of adopt this kind of approach to neutrality, do we lose some of that kind of containment benefit that neutrality sort of gave us?
I guess so. But we probably it's probably something that we have accepted by taking sides, as you say. But nonetheless, it's worth thinking of how much we can retain, and how much states perhaps want to retain of that old body of law residually, if you will. And this is, I think, what will remain of the law of neutrality, if you accept the premise that it is relevant at all today. And this, I think, you can sort of justify sort of in a positivist way by saying states still hold on to it, right? States still rely on the law of neutrality, at least occasionally, and then we know old rules die hard. And states even sort of looking to the future refer to the law of neutrality in their position papers on international law as it applies to cyberspace. So clearly, they at least pragmatically want to keep neutrality at the background, if you will. And it's sort of a very complex issue of discerning quite where exactly something is being left if we systemically integrate it with the prohibition of the use of force.
Do you think neutrality helps us in situations, I mean, at least the kind of concept of neutrality helps us in situations where it's contested who is the aggressor and who is not, that it sort of creates a space for states to adopt a kind of neutral position in situations of uncertainty? Is that something that can still contribute?
I mean, certainly that was the basic idea, right? Of having that agnostic state. And that is something where sort of people have traditionally said, well, this is why we don't want states to take sides, because it's almost always contested and uncertain. And the problem is that if we, as I would argue, and others do as well, on maybe different methodological grounds, if we accept an exception, then that will be an exception of which states will determine in a decentralized way for themselves whether to rely on it or not. But I think that is precisely why it is needed, because we are lacking that centralized determination very often. Yeah.
I wanted to come back to the question of methodology that you sort of flagged earlier and also just mentioned there, which is, I think, a really interesting part of the article, is that of course it's focused on this very particular topic, but the method you used to get there, I mean, it struck me that it could be described as a kind of systemic or evolutionary interpretation of custom, which is something that we don't really see. Obviously, we see those terms talked about in the context of treaty interpretation, but is that a fair account of the sort of methodological approach that you take?
No, definitely. I mean, I've hinted at it briefly, and that is, I think, exactly how I think we can get to that result, to that exception that I argue for, which is an exception that has traditionally been argued for in a sort of inductive way, right? People have had arguments on whether we have had enough consistent and widespread practice accepted as law. And I think that's a reasonable debate to have. And there are people who have said, well, yes, we've had enough, Stefan Talmont, for example, and others who've said, well, at least before Ukraine, not enough. And then the practice in Ukraine hasn't been entirely consistent either. So I think it does make a difference whether we're able to say we don't actually need that. And I think, yes, it's a methodological struggle to argue for why we can interpret custom. Others have made that argument, I think, convincingly, and I've sort of tried to apply that reasoning of, well, international law is a system, even if we think of customary international law. And if it is at least a system in some respect, then that will allow us to deduce implications from rules that are accepted by state consent. Yeah.
Fantastic. I'm just conscious of the time. I wanted to ask one final question, really, which is where you see, where you see your research going in the future? Is this something that, do you have sort of further plans to build on this, or your research is heading in different directions?
So it's, in a sense, it's connected to the extent that I'm still thinking of security-related issues. At the international law level, mainly of international courts as actors in peace and security, but they have recently become thinking of public interest litigation, indispensable third parties, and then also branching out a bit to public law more broadly and looking at national security, not only in international law, but also in EU law and comparative public law.
Fantastic. Well, we are all very excited to await your future research. But for now, thank you again and congratulations on your excellent article. For those interested in knowing more about the article, it's available open access through the ICLQ webpage. And I'd just like to ask if Rebecca from Cambridge University Press could join us to present Alexander with his certificate. His books, I think, have already been delivered, but this is a certificate to congratulate him on the prize. Thanks, sir. Hey, now to the annual lecture. So each year, the editorial board of the ICLQ invites the author of one of the most interesting and outstanding contributions to the journal in the previous year to deliver the ICLQ annual lecture. And this year, I'm delighted to announce that the annual lecture will be given by Professor Benoît Meyer. Benoît is a professor of climate law at the University of Reading. He previously worked at the University of Wuhan and at the Chinese University of Hong Kong. He's executive editor-in-chief of the Chinese Journal of Environmental Law and a member of the UNFCCC roster of experts. He holds degrees from the University Paris 1 Panthéon-Sorbonne, McGill University, and the National University of Singapore. And perhaps his most significant achievement, he's a previous recipient of the ICLQ's Early Career Prize. And so it's a particular pleasure to welcome him back, and no pressure, Alexander. The annual lecture will be based on his excellent article published in volume 73-2 of the ICLQ, entitled The Highest Possible Ambition on Climate Change Mitigation as a Legal Standard, which incidentally is also available open access on the ICLQ webpage. Congratulations, Benoît, and we welcome you to the stage.
Thank you very much. Thank you for having me. So I'm extremely grateful to Alex and Spiros and all the team of the ICLQ for editing my pieces one after the other and for inviting me again. It's a great pleasure to be here. So my presentation is not on, it's a more peaceful topic than the one we have before, but it's still a very hot topic on climate change. And so it's based, as Alex said, on my article published in ICLQ, but also trying to reflect on some of the recent developments, including the advisory opinions, the advisory proceedings before the International Court of Justice. There have been about 10,000 pages of submissions to the ICJ in those advisory proceedings. So there are actually a lot of documents to look at. International negotiations to address climate change have been going on for over 30 years, and they have led to the adoption of 3 treaties, the UN Framework Convention on Climate Change, the Kyoto Protocol, and the Paris Agreement. The Kyoto Protocol contains a list of quantified emission limitation and reduction commitments applicable to developed country parties, which these parties were to achieve during an initial commitment period that extended from 2008 to 2012. In 2012, the Doha Amendment defined similar commitments applicable to a second commitment period. In contrast to the Kyoto Protocol, the Paris Agreement does not impose emission reduction commitments to any state party. Instead, the Paris Agreement requires its parties to adopt and communicate nationally determined contributions, or NDCs. It's often said that those NDCs are voluntary, although the statement is at least somewhat misleading. The adoption and communication of NDCs is clearly not voluntary for the parties of the Paris Agreement. Article 4, paragraph 2 in the first sentence of the Paris Agreement provides that each party shall prepare, communicate, and maintain successive NDCs that it intends to achieve. Paragraphs 9 and 10 of Article 4 specify that parties must communicate NDCs every 5 years according to a common time frame adopted by the Conference of the Parties. Nor is the implementation of NDCs entirely left to states' discretion. The second sentence of Article 4, paragraph 2 of the Paris Agreement provides that parties shall pursue domestic mitigation measures with the aim of achieving the objectives of such contribution. This rather convoluted provision certainly does not create an obligation to achieve the NDCs or the objective of the NDCs. Instead, this provision has been interpreted as creating an obligation of conduct. Accordingly, parties must take reasonable and appropriate steps that they expect to be sufficient to ensure the goal that the goal of the NDC will be achieved. A breach of this obligation will occur if the state fails to take such reasonable and appropriate steps, notwithstanding whether the objective of the NDC is achieved. Thus, the oft-heard statement that NDCs are voluntary probably refers to the determination of their content. By definition, NDCs are nationally determined. Since the adoption of the Paris Agreement, the meeting of the parties has found it useful actually to reaffirm several times what it called the nationally determined nature of nationally determined contributions. In other words, parties must adopt NDCs and they must implement them, but they are largely free to decide what to include in those NDCs. As 5 European states put it during the ICJ advisory proceedings, it was a clear prerequisite of the unanimous adoption of the Paris Agreement that the determination of the NDC would remain subject to the discretion of sovereign states. This so-called bottom-up approach to the determination of national commitments on climate change mitigation was instrumental to the adoption of the Paris Agreement and to the nearly universal participation, with the exception of oil-producing autocracies like Iran, Libya, Yemen, and soon again the US. This approach, however, is also a major weakness of the Paris Agreement. The state might be better off if global efforts to mitigate climate change, a state may be better off with global efforts to mitigate climate change and without, but it will still be better off if the cost of making those efforts fall on other states. In other words, a state may seek to take advantage of the nationally determined nature of NDCs by free riding on the efforts of others. But of course, if every state was doing the same, no actual ambition would be reflected in national action. As such, it is perhaps not surprising that current NDCs do not reflect the level of ambition consistent with the objective of the Paris Agreement of limiting global warming well below 2 degrees Celsius and possibly closer to 1.5 degrees. Instead, the implementation of the current NDCs would only limit global warming to somewhere between 2.1 and 2.8 degrees. Yet this freedom of the parties to the Paris Agreement to determine the content of the NDCs is not absolute. Ecuador, during the ICJ proceedings, rightly noted that the discretion of the parties to the Paris Agreement in determining the content of the NDC is, I quote, not unlimited. NDCs must also reflect the highest possible ambition of the states concerned, and successive NDCs must go beyond previous ones. These two constraints are reflected in Article 4, paragraph 3 of the Paris Agreement. The first limitation can be framed as a principle of progression. Each party's successive NDC is thus expected to represent a progression beyond the party's then current NDC. Article 4, paragraph 11 allows a party to adjust its existing NDC with the view of enhancing its level of ambition, which in the context of the Paris Agreement and the negotiations has generally been interpreted as implying that no downward adjustment of an existing NDC will be permitted. A second limitation of the discretion of the party to determine the content of the NDC is the expectation that an NDC will represent the party's highest possible ambition. Now, the legal status of these two standards in Article 4, paragraph 3 of the Paris Agreement requires some attention. Article 4, paragraph 3 does not contain the word shall. It contains the word will instead, thus reflecting no intention of states of establishing a legal obligation. At most, Article 4, paragraph 3 establishes expectations, or as the European Union put it during the ICJ advisory proceedings, a substantive expectation. Nonetheless, these provisions may have an important implication for the interpretation of other norms of international law. It is now well established that states have a due diligence obligation to mitigate climate change arising from sources other than climate treaties, other than Paris Agreement at least. For one, the UN Framework Convention on Climate Change of 1992 requires all of its parties to formulate and implement national programs containing measures to mitigate climate change. Other treaties may also be interpreted as implying an obligation to mitigate climate change. Thus, the International Tribunal for the Law of the Sea, in the advisory opinion that it gave at the request of the Commission of Small Island States on Climate Change and International Law, or COSIS, interpreted the obligation of states to protect the marine environment under Part 12 of the UN Convention on the Law of the Sea as implying an obligation of due diligence to take all necessary measures to prevent, reduce, and control marine pollution from anthropogenic greenhouse gas emissions, in particular by reducing greenhouse gas emissions. And the European Court of Human Rights, in the recent decision of Ferreira and Klimasenjorinen against Switzerland, found the obligation to protect the enjoyment of the right to family life as requiring that, I quote, each contracting state undertake measures to the substantial and progressive reduction of their respective greenhouse gas emission levels. Beyond treaties, many states have argued before the ICJ that customary international law also imposes a due diligence obligation to take appropriate measures to mitigate climate change. If states truly have a right to the protection of their natural resources, they must also have an obligation to respect that right for other states, including by taking necessary measures to prevent global environmental harm. Some states have argued during the ICJ proceedings that climate treaties form a lex specialis, excluding the application of other norms of international law, whether conventional or customary in nature. Yet this argument is weak because there is no strict incompatibility, hence no conflict between climate treaties and other norms of international law potentially applicable to climate change. Different norms of international law emerge based on different conditions. The adoption of a climate treaty requires the consensus of the parties, which is an onerous condition when there are oil-producing countries in the room. By contrast, customary international law may develop based on general practice, which may be less than consensual. While climate treaties are seldom amended and thus represent a dated conception of the obligation of states on climate change, customary law is constantly evolving. Thus, both the European Court of Human Rights and its laws have found that states may be required to mitigate climate change based on sources other than the Paris Agreement and potentially more demanding than the latter. Therefore, while the standard of progression and highest possible ambition are not explicitly binding under the Paris Agreement, they could be among the standards that the court will take into account when determining whether a state has taken the appropriate measures that it was required to take under obligations to mitigate climate change arising from customary international law, multilateral environmental agreements, or human rights treaties. Indeed, 5 human rights treaty bodies at the UN have adopted a statement in 2020 in which they stated their understanding that national policies on climate change must reflect the party's highest possible ambition. Unsurprisingly, progression and highest possible ambition were also mentioned as potential benchmark to define due diligence in international proceedings, including before ICLOS, before the European Court of Human Rights, and also more recently before the ICJ. There, the European Union, for instance, presented a highest possible ambition as one of the normative parameters that inform the obligation of conduct and by extension of due diligence that bind the parties, including with regard to the level of ambition outlined in the NDC, in the NDCs. The EU added these normative parameters can allow for the assessment of whether parties have discharged their obligations of due diligence. Even the United Arab Emirates acknowledged, I quote, widespread agreement among states on their duty to pursue climate action with the highest possible ambition. If we accept that progression and highest possible ambition inform due diligence obligations on climate change mitigation, the next question that you may want to ask is what precisely these two concepts require from states. Progression may appear relatively straightforward. Ideally, it creates a ratchet mechanism. Even if a party starts with an ambitious NDC, its subsequent NDCs will become more and more ambitious over time. Yet, ambition and progression are more difficult to define than it may seem. Technical issues impede any comparison of ambition between two consecutive NDCs. For instance, if the new NDC introduces a different type of mitigation objective, or applies to different gases or different sectors, or if it relies on different emission accounting methodologies. These issues have already led to domestic litigation in Mexico and Brazil about whether the new NDC or the updated NDC was indeed progressive. But there are also more fundamental issues with the very concept of progression when applied to climate action. Consider, for instance, the UK, whose first NDC aimed at reducing national greenhouse gas emissions by 68% by 2030 compared with 1990. The second NDC had to define an objective for 2035. Would a 69% emission reduction by 2035 compared with 1990 have been sufficient? It's more than 68, right? Or is a state supposed to follow a consistent mitigation pathway? If so, should this pathway be considered as a linear pathway, kind of an extension of the line, if you will? Or should it be an exponential curve or a sigmoid curve, like kind of an S starting with very fast decrease in emission, like low-hanging fruits, and then addressing the more difficult sectors to decarbonize? Or should progression be understood in different terms entirely, as referring to a level of efforts, for instance, the implicit carbon price, that is the economic burden that the state's mitigation action and policies impose on its constituents? Another limitation of progression is that, well, if the initial NDC is not ambitious, it will take a lot of time for successive NDCs to become ambitious enough. And when addressing climate change, time is of the essence. As such, the standard of highest possible ambition is another essential component of due diligence. But what does highest possible ambition mean then precisely? Let me start by highlighting what highest possible ambition is not. Namely, it is not, in my interpretation, a requirement for a party to pursue its fair share in global efforts to address climate change. Even since the adoption of the Paris Agreement, scholars and activists have sought to develop a way to determine what the global 1.5 or 2 degree targets will require from each state. That is, if each state's fair share in global efforts necessary to achieve those temperature goals. A major difficulty with this endeavor is that there is no objective way or accepted way of sharing global efforts among states. Whether there are multiple relevant criteria for differentiation, ranging from historical emissions to financial capacity and geographical resources. States have long agreed on the principle that their efforts should reflect their common but differentiated responsibilities and respective capabilities. But this vague and ambiguous principle is far from defining a burden-sharing formula. For our purpose, it's important to note that Article 4, Paragraph 3 of the Paris Agreement does not refer to the temperature goals defined in Article 2, Paragraph 1 of the same treaty. Therefore, the highest possible ambition cannot be understood as referring to a state's fair share in global efforts necessary to achieve either temperature goals. Analyzing a state's highest possible ambition requires us to start by thinking about what the state can do rather than by considering what ought or needs to be done at the global level. To understand what highest possible ambition really means, then one needs to look at what the word possible means to start. Whether something is possible depends on the constraints one considers relevant. An obvious starting point is that a party is not expected to do magic. Geophysical and technological constraints, at least, must be recognized as relevant limitations to what can be considered as possible mitigation action. Economic constraints are also relevant, obviously. The Conference of the Parties has acknowledged that international assistance to developing countries could allow them to enhance their ambition. As the Bahamas noted in the ICJ advisory proceedings on climate change, what constitutes each state's highest possible ambition will be informed by resource constraints and thus vary based on the state's level of development. A more difficult question is whether or to what extent social and political constraints should also be considered as limiting what should be considered as possible ambition. There is a risk that a country's population may be strongly opposed to a level of ambition that will otherwise appear entirely feasible. Should additional mitigation action be considered possible when it will require the government to ignore the will of the people, potentially even to repress protests, such as the Gilets jaunes in France? A counter-argument is that such protests are against specific measures rather than against a level of ambition, and that the government could try to find different measures that will not be opposed by the people in the same way. Yet ambitious measures to mitigate climate change will always come at a cost, and that cost will always be politically non-palatable. Yet acknowledging political acceptability as a constraint limiting the highest possible ambition would potentially allow a political community to curtail its own ambition as it wishes by saying this is not acceptable, we want to do less. The case of Ferrain Klimasenjurinen against Switzerland before the European Court of Human Rights illustrates very well this tension between mitigation obligations and democratic processes. In 2020, the government of Switzerland passed a law aimed at implementing an updated NDC with more ambitious targets. The next year, a citizen-initiated referendum rejected the law and forced the government to walk back on its NDC updates, very likely a breach of the progression requirement. In 2024, the European Court of Human Rights held that Switzerland was in breach of its obligation to protect the right to family life due to its lack of climate ambition, largely due to the referendum. Since then, Swiss institutions have been less than keen to take additional measures to comply with the European Court's decision, and they have found that additional measures would not be politically feasible. And one large political party has even been campaigning for a withdrawal of Switzerland from the Paris Agreement. Now, ambition is another problematic term because it is ambiguous. A state's ambition can be expressed by reference to the expected outcomes, say a 50% reduction in national greenhouse gas emissions by 2030. Alternatively, it can also be expressed in terms of effort, that is the intensity of effort that the state intends to make. Efforts and outcomes differ for what concerns climate change mitigation because a state's greenhouse gas emissions depend in no small part from unpredictable extraneous factors, such as economic growth, the price of natural resources, not just oil and gas, but also rare earth elements, for instance. And the speed of technology, innovation, and deployment, all of this will have an impact on greenhouse gas emissions, and this impact is unpredictable. In principle, it would be sensible to define climate ambition in terms of the intensity of efforts, which means that the highest possible ambition would be essentially a best effort standard. In practice, however, efforts in climate policy are extremely difficult to measure. One might dream of a world, and some people do, of a world where every state imposes a carbon tax, the rate of which could be compared to compare the intensity of efforts of different countries or the intensity of effort of one state over time. In reality, however, not every jurisdiction is imposing any carbon pricing mechanism at all. And those that do so only apply such mechanism in specific sectors. The European Emission Trading Scheme, for instance, only applies to less than half of the emissions of the European Union. Most mitigation action policies consist in more traditional command and control regulations that impose a level of effort that cannot easily be measured and compared. Often these measures are not solely aimed at mitigating climate change, but also, for instance, at reducing local air pollution, which further complexifies any assessment of a state's overall efforts to mitigate climate change. Because efforts are so difficult to measure, states have generally expressed ambition in terms of expected outcomes, and highest possible ambition should also be understood in such terms. That is, for instance, as a percentage of emission reduction to be achieved by a particular time. The highest possible ambition standard implies some form of differentiation as well between states. All states have different highest possible ambition. Interestingly, however, the burden sharing criteria that this implies are somewhat different from those otherwise considered in climate negotiations. I alluded earlier to the concept of common but differentiated responsibility and respective capabilities, or CBDRRC, that is enshrined in all 3 climate treaties, including in Article 4, Paragraph 3 of the Paris Agreement. While there are perhaps as many interpretations of CBDRRC as there are parties to climate treaties, most states agree that this involves at least a capability-based criteria, that is the respective capabilities, and some sort of responsibility-based criteria, the responsibility bit. In contrast, highest possible ambition focuses exclusively on capability, on what is possible, to the exclusion of responsibilities. Parties are required to commit to do the best they can do, notwithstanding any form of culpability for past, present, and perhaps even future emissions. The difference between the highest possible ambition and CBDRRC can be significant in practice. For instance, in the case of Bhutan, a small state with no net greenhouse gas emissions, therefore arguably little, if any, responsibility for climate change, but the capacity to contribute to global efforts on climate change mitigation by further reducing its emissions by sources or further increasing its reforestation program. Bhutan has emissions from car, but it also has sinks from forest, and the sinks are more important, but it could be even, you could remove even more carbon dioxide from this country. There's no easy way to reconcile these 2 approaches to differentiations. Either Bhutan must do the most it can do, or it may be allowed to do less on the ground of its lesser responsibility. Likewise, a state with more responsibility, like arguably the UK, if you consider the historical emissions of the country, a state with more responsibility cannot be expected to do more than pursuing its highest possible ambition. I believe that the adoption of the highest possible ambition standard in the Paris Agreement reflects a focus on capability rather than responsibility in the way states share global efforts to mitigate climate change. Sierra Leone presented a similar view during the ICJ advisory proceeding when stating that by endorsing the principle of highest possible ambition, the Paris Agreement makes clear that developing countries cannot use the CBDR principle as an excuse for not doing more. By fully mobilizing every state, this approach of highest possible ambition reflects the urgency of taking cost-effective global action to mitigate climate change. This does not mean, however, that the responsibility component of the CBDRRC principle has fallen into disuse. It has not. But just that this component has become relevant in other aspects of climate cooperation. For instance, the responsibility criteria may be more relevant when determining a state's obligation to assist other countries with their own efforts to address climate change, whether through mitigation or adaptation action. Another somewhat problematic relation between highest possible ambition and something else is between the highest possible ambition standard and the principle of progression that I mentioned earlier. States have sometimes invoked progression to suggest that their new NDC reflects the highest possible ambition. Yet one may retort that, if anything, a party's ability to progress seems to reveal that the party's previous NDC did not truly reflect, or no longer reflected, its highest possible ambition. If the party's NDC already reflected its highest possible ambition, then by definition, no progression would be possible. One way to avoid this conundrum between the two standards in Article 4, paragraph 3 of the Paris Agreement would be to interpret highest possible ambition in terms of efforts and progression in terms of cumulative outcomes. By continuously doing its best as required by the highest possible ambition standard, a party will come increasingly close to a sustainable development pathway as required under some interpretation of the progression standard. Now, all of these reflections may appear somewhat abstract, and there is indeed a frequent assumption in the climate law scholarship that the highest possible ambition and standard is ineffective. I understand the limitation of the standard, in particular, the difficulty of undertaking objective assessment of what precisely constitutes the party's highest possible ambition. Nonetheless, I do believe that this standard is not entirely irrelevant and that it can be implemented in some cases. Determining whether a party's NDC reflects its highest possible ambition can conceivably be done in two distinct ways. The first, most obvious way will consist in an objective assessment of the state's highest possible ambition by an extraneous institution. It could be a court, an independent administrative body, or an NGO, or anyone. However, this assessment will inevitably rely on a number of questionable assumptions. This is partly because the concept of highest possible ambition is ill-defined and reasonable disagreement is possible, for instance, as to the relevance of political constraints in assessing whether a level of ambition is possible. But this is also partly due to factual uncertainties, especially if ambition is expressed in terms of expected outcomes, rather than in terms of the intensity of efforts. Two separate entities seeking to determine a state's highest possible ambition will very likely reach completely different conclusions. These considerations have led to considerable opposition to any objective assessment of a state's highest possible ambition, as reflected again in the advisory proceedings before the ICJ. For instance, some European countries have asserted that it is up to each party to determine its highest possible ambition. Kuwait similarly has argued that the concept of progression and highest possible ambition are not quantifiable concepts capable of objective determination other than by a state itself. They are to be determined by each state party. The US submitted that neither Article 4.3 nor any other provision of the Paris Agreement provides any legal standard against which to judge the sufficiency of a party's NDC. I do not find these positions entirely convincing as a matter of treaty interpretation, because they tend to deny any effective role to the provisions of Article 4, paragraph 3 of the Paris Agreement. While it belongs to the state to determine their NDC, Article 4, paragraph 3 defines limitations to this discretion to the discretion of states in doing so, and courts can control compliance with these limitations. Yet it remains that courts will rarely feel sufficiently confident in their assessment of a state's highest possible ambition to rely on this alone to find a state in breach of its due diligence obligation to mitigate climate change, save perhaps in extreme circumstances. For instance, if a state's NDC was reflecting no genuine ambition at all. Nonetheless, an extraneous assessment of a state's highest possible ambition has a role to play in other non-judicial processes, for instance, in informing recommendations by independent administrative authorities, or even political processes, including elections and referendums. Now, the second way of determining whether a party's NDC reflects its highest possible ambition relies on the party's own assessment of this highest possible ambition. A state will appear to be in breach of its highest possible ambition standard when its NDC is less ambitious than what the state itself has identified as its highest possible ambition. Evidence of such inconsistency between the state's assessment of its highest possible ambition and the content of its NDC becomes more likely when a state is detailing its assessment of its highest possible ambition in multiple documents. In this regard, it is remarkable that each time a party to the Paris Agreement communicates a new or updated NDC, it is required to explain how its NDC reflects its highest possible ambition. Perhaps unsurprisingly, many parties have fulfilled this condition through the mere assertion of compliance, and these assertions have remained unchallenged. Yet some parties have felt compelled to provide detailed explanations of their understanding of their highest possible ambition, both in their NDCs and also in some of their biennial reports on the implementation of climate treaties. Over time, these declarations and statements clarify how each party is determining its highest possible ambition, which in turn provides fodder for political advocacy and legal proceedings if the party adopts then an inconsistent NDC. In conclusion, Article 4, Paragraph 3 of the Paris Agreement reflects an expectation that each NDC will reflect the party's highest possible ambition. This expectation can inform the interpretation and application of due diligence obligations on climate change mitigation arising from under various norms of international law. Admittedly, any assessment of a state's highest possible ambition is impeded by factual and conceptual issues relating, for instance, to the various possible ways of defining what is possible. Nonetheless, the highest possible ambition standard can assist with clarifying the content and nature of due diligence obligations on climate change mitigation. And there could be some opportunities for applying the highest possible ambition standards through various political and judicial processes. While I'm skeptical of the ability of a court to conduct its own objective assessment of what constitutes a party's highest possible ambition, I believe that in some circumstances, a breach of the standard could be established based on the state's own assessment. The ICJ's forthcoming advisory opinion may lead to some clarifications on the role and significance of the highest possible ambition standard. I expect that the ICJ, like ICLOS and the European Court of Human Rights, will confirm the existence of due diligence obligations on climate change mitigation arising from sources other than climate treaties, perhaps with an emphasis on customary international law, that is a law applicable to all states, notwithstanding their readiness to participate in various treaties. Referring to the principle of systemic integration, the ICJ might interpret such due diligence obligations as requiring national climate policies to reflect progression and highest possible ambition. What I'm most curious to see, however, is how far the ICJ and in other international courts would be willing to go in applying these standards, including possibly by imposing their own determination of what is the state's highest possible ambition. I thank you for listening. I'm very much looking forward for discussing this with you. Thank you.
Thank you very much, Benoît. We have some time for questions, either from the room or from those listening in online. Does anyone have any questions they would like to ask? Perhaps I can kick things off while people are coming up with questions. I suppose one of the challenges, and it's a challenge that you talk about in the article, is the complexity of what possible might mean, and whether it's such a complex concept if you build in considerations of political considerations and socioeconomic considerations, cultural considerations. It starts to sound like something that would be that a court would struggle to view as justiciable, right? Whether there's a kind of meaningful standard. I mean, do you think there nevertheless, because there are other aspects of it which do seem more concrete, I suppose, if you think of the kind of economic or maybe technological. Do you think, do you think a court could navigate its way through these kind of multiple dimensions of possibility?
Thank you. Probably not. I mean, I think it's a huge challenge. I mean, there are like many different constraints of what is possible. Clearly, I mean, physical rules are here sometimes. To some extent, you could say that it's possible for the UK to stop greenhouse gas emissions today. It just will have a tremendous social and economic cost. It just means we have to stop the economy, but it's possible, right? So then, really, there must be a question about economic possibility and like political possibility and social possibility. But then you end up with self-fulfilling prophecies about, like if the voters are opposed to it, well, it's not politically feasible. But then, I suppose good politicians are not just listening to the people, they're also educating the people and changing their view to some extent. So that political feasibility is a very fluid concept. Do courts have any ability to understand what is politically feasible and how much constraints socially acceptable? Probably not to a large extent. So, and that's really the reason why many believe that this concept is just not a legal concept, and that's a purely political issue. Now, I will argue against that. I would say, like, in a case before a court where you have an argument about whether the state should reduce emissions more or less, there are rights and obligations at stake. Those are legal rights and legal obligations, and the court will have to give an answer if you accept that non-liquid is not a possibility. And this answer will have to be based on an interpretation of the highest possible ambition. There could be issues of burden of proof. Of course, the court could say we don't want to, we defer a lot to the state's own assessment. But I don't think the court could say this is an entirely political issue that we will not deal with, because there will be a legal issue that the court will have to answer.
Does anyone else, does anyone have any questions? Perhaps we'll start over there and need to wait for the microphone. Thanks.
Hello, my name is Xuexia Liao. I come from Peking University, and now I'm actually a visiting fellow at the British Institute here. And thank you very much for your presentation. And actually, I have a question relating to the ICLQ's climate change advisory opinion on its interpretation of the due diligence obligation, because as you already mentioned, that ICLQ's interpreted the there exists an obligation of due diligence under Article 194, paragraph 1 of UNCLOS. And also it mentioned that the standard for this due diligence obligation is stringent. And so I wonder, given your argument on that the highest possible ambition may inform the interpretation of due diligence obligation, I wonder, do you think this highest possible ambition may imply a similarly stringent standard of due diligence under climate change and climate change instruments? And also relatedly, I'm very curious of your view on what this stringent standard of due diligence entail, and what practical differences for the states in their compliance with the due diligence obligation. Thank you.
Thank you very much. So ICLQ's advisory opinion suggested that states have a stringent due diligence obligation. It was mentioned a number of times in the advisory opinion. It was really something the tribunal wanted us to remember. However, the tribunal did not really find it useful to define this term. So of course, due diligence is a variable concept, right? How much you expect from a state depends on a lot of things, like the urgency of the goal that you're trying to achieve, the constraints that you're facing, and so on. So take this stringent to be a reflection of, among other things, the fact that the parties to the Paris Agreement had included the highest possible ambition in the Paris Agreement, and had defined relatively ambitious targets, like the 1.5 and 2 degree targets. The 1.5, we are kind of sure we will not achieve it. So if states agree on ambitious goals, then they implicitly agree on the stringent due diligence obligation, I would say. So in my view, those are kind of similar, actually, similar effect, the stringency asserted by ICLQ and the highest possible ambition agreed upon by the negotiators in Paris. Both of them just highlight, okay, when comparing the cost and the benefit of taking action to address climate change, we should give a lot of importance to the benefits. It's really important to address it. It doesn't give us a formula to determine what should be done by the UK by 2035, but it helps to understand that we should give some weight to the benefit of reducing emissions.
I think there was another question over there. Yeah.
Hi, thank you for your presentation. I'm Grisela. I'm a researcher here at BICO. I want to build on the first question. You discussed that, you understand that it would be difficult for courts to objectively assess the highest possible standards for states. But you also made a distinction that it might be feasible for political processes and administrative tribunals to actually make this determination. So I'm curious, how do you envision, states and administrative tribunals to objectively assess highest possible standards for different states?
Well, so administrative tribunals, I would put them with the courts here. I would say it's very unlikely for a court to do an objective assessment of the highest possible ambition. It's not impossible, but no, it would be. I mean, I think in the UK it would be a Wensbury and reasonableness standard. So you have to have very clear evidence that there is no ambition at all in this NDC, and therefore, I mean, those cases would be quite obvious. I'm more skeptical of a case like we have seen in Netherlands, where the court took 25% from their heart and say, okay, that's the target the Netherlands should achieve, based on very questionable reasoning. So I don't think you will have something objective enough for a court unless the court really is against the rule and has to give a number, as there would be the case possibly in a dispute between two parties. So what I refer to in terms of political processes, like in the UK, you have the Climate Change Committee that is in charge of advising the government on the ambition that they can put in their climate action, and other countries have similar processes. So that's what I had in mind. If the Climate Change Committee is asked to give a recommendation on what can we do by 2035 or 2040, and so the committee will be able to look at the economic constraints as well as the others, and say, okay, we expect that we could be able to achieve, I think it's 89% that was deciding for 2035. And that's, of course, very subjective political concept that will then be debated and potentially altered by the government and by the new government and so on. Yeah, so probably, so in terms of political assessment, I think, that's a bit more open-ended, really, and there's not really a clear process, a clear methodology. It will just be about arguing that we can do more, I believe.
There was a question online, which I'll take first, and I think there's another couple of questions in the room. The question online, which comes, I think I can read out his name, Donovan Story, was, can highest possible ambition also refer to a more complete inventory of greenhouse gases beyond CO2? So I suppose it's a sort of breadth rather than necessarily kind of intensity question. And how do you see Article 13 on transparent reporting and technical expert reviews as shifting the debate? Because the various principles there, transparency, accuracy, completeness, consistency, and comparability, will be applied to NDC reporting.
Thank you. So there has, I mean, the Paris Agreement and the subsequent decisions on the implementation use the concept of progression a lot for those reporting requirements. Like the parties are supposed to progress in the quality of their reporting. And you also have rules on that suggest a progression in the scope of the NDC in Article 4.4, for instance, of the Paris Agreement. That the developing countries should move towards an economy-wide target. I find it a bit more difficult to apply highest possible ambition to reporting, in the sense that, I mean, I will have to check really, but I don't think the concept of highest possible ambition has been mentioned anywhere else in the Paris Agreement or in the Paris Rulebook, on the decisions and implementation of the Paris Agreement. So I don't really see any treaty basis for that. But progression is there, and to some extent, it may have a relatively similar effect. So parties are required. I mean, developing countries, for instance, at the moment can invoke flexibility for some aspects of reporting, and this flexibility has to be temporary. So there has to be a progress over time in the reporting by developing countries so that we have a better idea of like what emissions they are causing and what they are doing about it.
Does transparency help with the kind of sort of internal review that you're sort of talking about, measuring a state against its own, I suppose, analysis of what it can do?
It can. So it will be entirely speculative because the Article 13 reporting mechanism is just starting to be implemented. There's a lot of implementation time. The first reports have been given, and the reviews are just starting. I'm going next week to Mauritius to do the review of their reports. So we don't really see how it's happening yet, but there have been reports under the UN FCCC before, obviously. So those reports kind of require the parties to some extent to describe their NDC and to justify the ambition embedded in the NDC to some extent. This is not subjected to review, however, so in principle, I think in the paper that I published last year, I mentioned that there is the possibility for political processes that will review the review of the review of the report. So there is political process at the end where the states look at the report on a review of the report. And so I suggested that this political process could be used as a way to challenge the ambition or the lack of ambition from other states. And that's probably if there has to be a UN climate process where ambition can be questioned, that would probably be that one. So yes, indirectly, I mean, the transparency framework will give opportunities and pressure for states to justify their ambition and potentially the opportunity for other states to question their potential lack of ambition.
Can I just take you back to the first part of the question that I read out, which was whether highest possible ambition could refer to a more complete inventory of greenhouse gas emissions rather than just a focus on CO2. So could it sort of also deal with the kind of comprehensiveness of the kind of accounting that states are doing?
On the accounting, I don't think so, because I don't think Article 4.3 applies to Article 13. It's a different article of the treaty. The question might be about the scope. I've not read the question, obviously. I think everybody has not. If it's about the scope of the NDC, then it's possible. But it's a different question, right? You have the question of what do you include in your target, and you have the question of what you include in your report. And it might not be the same, which is weird.
Is there a question? Yeah.
Hi, Ross Beaton, I'm a barrister. Just going back to this notion of what sort of standard an international court might be willing to engage with. Thinking it through, if it was, say it was the UK, decided that it was going to increase its emissions, presumably that would be that clearly wouldn't be the highest possible ambition. Would you agree with that? And so if an international court would engage with that in the case of a developed economy, would it be the same for a developing economy, for instance? Would there be exceptions where a country could say, well, our economy's gone backwards, or our population has risen, or technological change has not delivered the benefits which we thought that there would be? I'm just casting around as to whether there is a sort of a lower level threshold at which the ICJ might be willing to engage.
Right. So the UK's emissions have been decreasing quite steadily for the last 20 odd years. So, there will be quite a considerable change of, so I think that will be quite a clear case of a lack of ambition, to say the least. And you probably have to take active policies to increase emissions at that moment. Well, the same, and that's probably the same for most, or I think every developed country the emissions have been decreasing. I'm not sure for Turkey. I'm not sure if that's a developed countries. They are very sensitive on that issue, but for most of the clearly developed countries, that would probably be the same. And I would need to check Article 4.4 if it's Article 4, paragraph 4 of the Paris Agreement requires developed country parties to adopt, I believe, emission reduction targets. So that would be actually a quite clear case here. Yeah, so that's what but that's not a realistic scenario. What is more realistic is not a change in the kind of curve, or I think what
may have mentioned in the article is like if you have a state whose emissions are increasing, a developing country, like many developing countries have very low emissions per capita and they're still increasing, you know, that will continue to increase very likely. Should the rate of increase decrease, or should, like, what are you looking at to measure ambition or progression in that case? And could there be circumstances? I mean, I don't think that would be the case for the UK, but for when you're kind of borderline and you have some circumstances, it might be like you're at war with a country and you can't get the natural gas anymore, so you have to revert to coal, and that will increase your emissions. There may be circumstances where emissions have to increase for, even so you keep making the same effort to reduce emissions. Some extraneous factors make it such that your emissions increase. We see that on a small scale in terms of the weather. If you have a harsh winter, you have more heating and you have more natural gas consumption. So you will see a bit more emissions. The lines is never a clear line, it's always moving a little bit. So that's really the issue with measuring ambition and progression in terms of outcome. We should use efforts if we could, but it's almost impossible in practice. So yes, in the case of the UK increasing their emissions, clearly it would be a lack of ambition, but in more realistic cases, I think it's always a bit more tricky, and you will have to look at the circumstances again.
I think there was a question there first, and
Thanks. And thank you very much for the presentation. I just had one question about highest possible ambition and progression. And I was wondering whether there are other concepts or similar concepts in other areas of international law where we might kind of have lessons to be learned from how courts and tribunals have addressed those obligations, and or how states have addressed or implemented those obligations.
Thank you very much. I have a PhD student working on that in Hong Kong actually at the moment. So the areas of international law that we identified are human rights law and other aspects of environmental law. I think for economic and social rights, it's, there is this concept of like constant progression, and in other aspects of environmental law as well, also a bit less firmly established. Very often it's based on some very extensive interpretation of a would-be customary principle of progression based essentially on Article 4, paragraph 3 of the Paris Agreement, which is very little evidence of general customary international law on any environmental law aspect. But under domestic law, you have some standards applicable in different jurisdictions. In France, for instance, of non-regression, at least in environmental matters. Not sure if there's sufficient practice to really support the view of there being a general customary rule on progression in environmental matters.
Yeah, thanks so much. I'm Lawrence Hill, Cawthorne, University of Bristol. Really, really interesting presentation. I had pretty much exactly the same question. Partly, this concept of progressive realization, the economic and social rights, but I also wondered whether there might be any useful analogs to other areas of international law, also in respect of the point you made about the alleged self-judging nature of the obligation, and whether there might be an analogy, for example, to non-precluded measures clauses in trade and investment agreements and the way international tribunals have interpreted those, both on the point about self-judging interpretations, but also in terms of standard of review.
Right, I can't really speak about the investment law part. It's not really my field, and I'm not sufficiently aware of that. But so you kind of asked the question that Jean-Paul, I believe, has asked, and the second part of the question, which I forgot to answer, which is, how much climate law can learn from that, and perhaps how much the other field can learn from climate law. As a climate law specialist, it might be something I expected to say, but I found that progression is much more difficult to assess in climate law for all the reasons I've mentioned, but we don't even know how to measure ambition, how to compare ambition, and so on. Then it will be, for the realization of the right to housing. You can look at how many people have housing and not over time.
mean, there would be like KPIs or metrics you could use for most economic and social rights. I suppose that would be more directly impacted by governmental action than greenhouse gas emissions are in regard to climate change. We have to understand that a lot, I mean, the change of policy in the US, for instance, has not fundamentally changed the prediction of greenhouse gas emissions in the US. We have to understand that a lot of this happens because of global diffuse impact. If the UK is subsidizing EVs, for instance, that will make the cost of producing EVs cheaper, and other markets will benefit from that. Same for solar panels and so on. So you have companies, you have local governments. It's not just a central government kind of decision that is in a very simple way causing emissions to decrease. There are much more forces impacting emissions. So I suppose there could be some inspiration in terms of litigation, for instance, from social and economic rights. But I think it has to be limited, and there has to be a caveat, which is the complexity of really measuring ambition in climate change.
The concept of necessity, I suppose, is one that suggests itself as a similarly challenging concept to which courts have struggled with the extent to which necessity is justiciable, and I think that's probably what Lawrence is hinting at there as well. There was a question online from Deborah, which I'll read out. So the question is whether disabled people have been referred to in the cases and opinions that you've covered, especially the right to life. So I guess particularly the concerns around the most vulnerable people, and then the need for them to be taken into account.
Right. There is a case pending before the European Court of Human Rights of Müller against Austria regarding the right to life, I believe, of a person with disabilities. So that's something standing before the European Court. I mean, that's raises a completely different issue, which I've been working on since I wrote this paper, which is the concept of victimhood in climate litigation. Can someone be considered a victim of not just climate change, but of the failure of a state to take sufficient action? And courts have sometimes accepted that. Even the European Court of Human Rights in the case against Switzerland was very ambiguous and took an extremely complex approach that nobody seems to understand, not even them, but saying that an NGO had standing to represent victims, but none of the individuals before the court were victims, and it's not really clear who the victims were in that case, if any. And victims, of course, is a condition for standing under Article 34 of the European Convention. In my view, it's there won't be enough. I mean, depending on the legal standard applicable in a particular case, but in most cases, I find that there's not enough causal proximity between the potential breach of an obligation to reduce emissions by a state and the situation of any individual for there to be a victim in a legal sense. The impact of climate change, the adverse impact of climate change, is primarily for future generations and for nature. It's not really for the individual. The individuals will be much more affected by the taking of measures aimed at reducing greenhouse gas emissions, which will come with a cost that those individuals will have to bear.
Okay, I think that's probably as much as we should impose on you. Thank you so much to both our speakers for their really insightful and interesting remarks, and thank you for the lecture and for your wonderful answers to questions. And thank you all for coming, and you're all invited to join us for a drink, which is going to be down one flight of stairs. Please feel free to follow directions down, and I hope to continue the conversation over a drink. Thank you all very much.